Okay, let's unpack this. Imagine you're standing before a jury, or maybe you're just a few weeks out from one of the toughest exams of your life.
Yeah, the bar exam looms large for sure.
It really does. And you're facing these questions. What exactly defines a crime? What makes someone truly responsible in the eyes of the law?
These aren't just abstract academic questions either.
Not at all. They are, quite literally, the bedrock of our entire legal system. So today we're taking a deep dive into the foundational principles of criminal law.
Getting right down to the essentials.
Exactly, our mission. To really dissect the core elements, explore the different types of crimes, and navigate those crucial defenses, we want to give you a clear, structured understanding that actually cuts through the complexity.
Make it make sense.
Right. So whether you're gearing up for the bar exam, brushing up for, a big legal discussion, or just intensely curious about the mechanics of justice, this deep dive, which is informed by a pretty comprehensive legal review outline we've got here, it's your shortcut.
Yeah, a way to get genuinely well-informed without feeling totally overwhelmed by it all.
Precisely.
And what's really fascinating here, I think, is how these concepts that sound simple, wrongful act, a guilty mind, how they're woven together.
Like threads in a fabric.
Exactly. Woven together to determine accountability. It's like building with legal Legos.
Yeah.
Really. Each piece needs to fit just right.
I like that analogy.
We'll be exploring these fundamental building blocks of criminal liability and showing you precisely how a slight shift in a fact pattern, even a tiny detail,
Don't change everything.
completely alter the outcome of a case.
Yeah.
And this raises a really important question for anyone navigating the legal landscape, especially if you're facing a complex problem on an exam.
Which our listeners likely are.
Right. How do you systematically approach a criminal law scenario? We'll be laying out that roadmap for you today, giving you the practical tools to break down even the most complex situations into, well, manageable, testable pieces.
That's a perfect setup. So, to really get a grip on criminal law, we have to start at the absolute beginning, Chapter 1. General principle is the foundation of it all.
The bedrock, like you said.
Yeah. Think of it like this. Every single crime, at its heart, requires three fundamental things to have happened. I often visualize them as like the three legs of a stool.
Okay.
If even one leg is wobbly or just missing entirely, that's stool the crime. It simply can't stand up in court.
That's a great visual. And these three essential elements are actus reus, mens rea, and causation. Let's define each one because their precise meanings are absolutely crucial.
Okay, let's do it.
First, actus reus. That's the wrongful act itself, the physical part. It's the external manifestation of the crime.
So what the defendant actually did.
Exactly. What they did, or sometimes what they failed to do. It's not just about what they might have been thinking.
Got it. Actus reus is the act.
Second, mens rea, often translated as the guilty mind. This is the individual's mental state, their inner intent or culpability that goes along with the act.
The internal part. The why or how.
Precisely. And finally, causation. This is the causal connection. It's the link between that wrongful act, driven by the guilty mind, and the resulting harm.
The bridge between the act mind and the bad result.
Exactly. Without this unbroken chain, there's no criminal liability for that specific outcome. You can have an act and an intent, but if they don't cause the prohibited result, well, something's missing legally.
Okay, so let's start with that doing part, the actus reus. What exactly counts as a criminal act? Because you said it's more nuanced than just they did something bad.
It really is. The core requirement here is a voluntary affirmative act.
Voluntary and affirmative, okay.
And that act has to cause a result the law prohibits. Voluntary means the defendant must have exerted conscious will to perform the action.
So not like if you're sleepwalking or something.
Exactly. So if someone commits an act while they're unconscious or sleepwalking or under hypnosis, that's generally not considered a voluntary act for criminal liability.
It makes sense. You didn't choose to do it.
Right. And you can wish ill upon someone all day long. Wish our coffee machine would spontaneously combust.
We've all been there.
Haven't we? But until you take a voluntary step towards that ills, like, say, actually tampering with the wiring, you haven't committed an actus reus. Bad thoughts alone, thankfully, are never enough.
Phew. Okay. So an actus reus is usually an action, but you mentioned failing to act.
Ah, yes, criminal omissions. Yeah. This raises a very important and often counterintuitive question.
Mm-hmm.
What about not acting?
Right, the bystander effect kind of situation.
Exactly. While generally, under common law, there's no affirmative duty to rescue or help a bystander, even in seemingly dire or unsympathetic situations.
No one's legally forced to be a hero.
That's the general rule. But there are 5 key instances where an omission, a failure to act, can be a criminal act. And that's because a specific legal duty to act exists in those cases.
Okay, what are those 5? This feels important for exam spotting.
Definitely. First, a duty can arise by statute. Think of something as, well, mundane as filing a tax return. The law requires you to file. If you don't, that omission is a criminal act because the statute explicitly mandates it.
Got it. Statute says act, you don't. That's an omission.
Second, a duty can arise by contract. A classic example is a lifeguard. They have a contractual obligation to save a drowning person within their scope of duty.
So if they just watch someone drown.
Failing to act in certain circumstances where they have that duty could lead to criminal liability for the omission.
Okay. Contractual duty. What's third?
Third, a special relationship can create a duty. This famously includes familial ties, like a parent's duty to their child or even a person's duty to their spouse. The relationship itself imposes an obligation to act.
Parent, child, spouse, spouse. Makes sense.
Number 4. Fourth is called a detrimental undertaking. This is key. If you start to help someone voluntarily.
Like you pull someone out of a ditch.
Exactly. But then you abandon them, maybe leave them by the side of the road in a worse condition than they were before you intervened. Your omission to continue helping could be criminal because you started, and by stopping, you made their situation worse.
So don't start unless you're prepared to follow through reasonably.
That's the idea. And fifth, if you caused the victim's peril. If your own actions put someone in danger, you then acquire a legal duty to aid them.
Like if you accidentally hit someone with your car.
Precisely. You then have a duty to render assistance because you caused the dangerous situation. So the key insight here is how the law balances individual liberty, not forcing heroism with societal expectation in specific contexts.
So the general rule is no duty to act.
Right. No matter how unsympathetic a bystander might seem, if they weren't involved in creating the peril and don't fall into one of those 5 duty categories, there's generally no legal duty to act.
But those 5 exceptions are where criminal liability for not acting can arise. Crucial to remember.
Very crucial. It's a common test point because it really challenges that general no-duty rule.
Okay, so if the actus reus is what you did or failed to do, the mens rea, the guilty mind, feels like the really tricky, almost psychological part of the puzzle. How do we even begin to unpack intent when it's all internal?
That's a great way to put it, because it is internal, and the law has developed different ways to try and categorize that internal state. The fundamental principle, as we said, is that a crime requires that criminal act, the actus reus, coupled with a guilty mind, the mens rea.
Act plus mind or crime, usually.
Exactly. That pairing is essential for criminal liability, except for a very specific category of offenses known as strict liability crimes. We'll get to those. But for most crimes, you need both.
So how do we categorize that mental state?
Well, to truly understand mens rea, we often categorize it differently under common law versus the Model Penal Code, or MPC. Both systems are important for you to know.
Okay, let's start with common law then.
All right. Under common law, we typically break mental states into 3 main types. First, you have specific intent crimes.
Specific intent sounds like you need a very particular goal in mind.
Precisely. These crimes require a subjective desire, a specific objective, or knowledge of the prohibited result. It isn't just about intending to do the physical act, but intending a particular, often precise outcome.
Got it.
Now, there's a super helpful mnemonic for remembering the main specific intent crimes, especially for the bar exam. It's FIAT.
FIAT. Okay, what does that stand for?
F is for first-degree murder, the statutory kind requiring premeditation. A is for inchoate offenses. That includes attempt, solicitation, and conspiracy.
Ah, the incomplete crimes we mentioned.
Yes. A is for assault, specifically assault with intent to commit battery. And T is for theft offenses. It's a big category, including larceny, larceny by trick, false pretenses, embezzlement, forgery, burglary, and robbery.
Wow, okay. FIAT covers a lot of ground. Why is it so important to identify these?
Here's the key insight and why FIAT is useful. Certain crucial defenses, like voluntary intoxication or an unreasonable mistake of fact, are only available as defenses for these specific intent crimes.
Only for FIAT crimes.
Generally, yes, because those defenses can specifically negate the required subjective intent. If you were too drunk to form the specific intent to steal, for example, that could be a defense to larceny. It's a vital distinction for your analysis.
Huge. Okay, specific intent, FIAT, check. What's next under common law?
Next, we have malice crimes. The main examples are common law murder and arson. These require a reckless disregard of a high risk of harm.
Malice. Does that mean like evil intent, spite?
Not necessarily. That's a common misconception. It's important to clarify that malice here does not require ill will towards the victim. Instead, it's about committing the criminal act without excuse, justification, or any mitigating factors. It signifies a deep indifference to a known high risk to human life or property.
So extreme recklessness counts as malice.
Essentially, yes, a depraved heart kind of indifference.
Got it. And the third common law category?
Finally, there are general intent crimes. These only require the intent to perform the unlawful act itself, without needing any specific desire for a particular outcome beyond the act.
Just intend the act, not the result.
Right. Examples include manslaughter, battery, rape, kidnapping, and false imprisonment. If you intend to perform the act of applying force to someone, like a punch, that's generally enough for battery. You don't need to have specifically intended to break their nose or cause any particular level of injury. The intent is to perform the prohibited act.
Okay, that makes sense. A specific intent needs a specific goal. Malice needs extreme recklessness. General intent just needs the intent to do the bad act.
That's a good summary of the common law categories.
But you said the model penal code is different. I know a lot of modern statutes use that framework, and it seems to go into more detail on mental states.
You're absolutely right. The Model Penal Code, or MPC, offers a more granular and, frankly, more precise hierarchy of mental states. You'll frequently see its language reflected in modern statutes you encounter.
Okay, what are the MPC levels?
The MPC lays out 4 levels of culpability. The highest level is purposely.
Purposely. Sounds like specific intent.
It's very similar. The defendant's conscious objective is to engage in the conduct or to cause a certain result. This is the clearest form of intent, the I want this to happen mindset.
Okay, what's below purposely?
Slightly less demanding is knowingly or willfully. Here, the defendant is aware or knows that the result is practically certain to occur based on their conduct.
So maybe causing the result isn't their main goal, but they know it's going to happen.
Exactly. They're aware of the high probability, the practical certainty. They know it's going to happen as a consequence of their actions.
Okay, purposely, knowingly.
Then there's recklessly. Under the MPC, this means the defendant acts with conscious disregard of a substantial and unjustifiable risk.
Conscious disregard. So they see the risk, but they do it anyway.
Precisely. This is about being aware of the risk but choosing to ignore it and proceed anyway. They see the danger, but decide to roll the dice. This is different from malice's extreme indifference. It's conscious disregard of a substantial risk.
Got it. And the lowest level?
The lowest level of culpability under the MPC is negligently. This means the defendant should be aware of a substantial and unjustifiable risk that a material element of a crime exists or will result from their conduct.
Should be aware. So they weren't actually aware.
Correct. Negligence signifies a gross deviation from the standard of care that a reasonable person would observe in the situation. They don't see the risk, but a reasonable person in their shoes would have.
That's a big difference from recklessness, where they did see the risk.
It's a huge difference and often tested. Recklessness requires subjective awareness of the risk. Negligence is an objective standard should they have been aware.
Purposely, knowingly, recklessly, negligently. PKRN. Okay. That's a clear hierarchy.
It is. And here's a very practical tip for statutes you'll encounter, say, on an exam. If you see the phrase, with intent to, it usually signifies a specific intent crime, mapping roughly to MPC's purposely. If it says knowingly or recklessly, that often points towards a general intent crime corresponding to those MPC levels.
Okay, good rule of thumb.
And if there's no intent language at all in the statute defining the crime,
That's the signal for.
that's often a strong hint that you might be dealing with a strict liability crime.
Right. The exception where mens rea doesn't matter.
Exactly. These crimes are unique because they have no mens rea requirement whatsoever. Proof of the criminal act, the actus reus, alone is sufficient for conviction.
What are some examples?
Classic examples include statutory rape, where the defendant's knowledge of the victim's age is irrelevant, bigamy in some jurisdictions, or certain public welfare offenses like food and drug regulations or traffic violations.
So you just have to do the act. Doesn't matter what you were thinking.
Correct. Because these crimes remove that crucial element of a guilty mind, they are generally disfavored in the law. So courts usually require clear legislative intent to dispense with the mens rea requirement before they'll enforce a crime as strict liability.
It's an interesting philosophical point, isn't it? How much the law cares about what's inside your head versus just what you did.
It really is. It's a constant tension in criminal law.
Okay, so we've broken down the act, the mind. What about situations where you didn't commit the act yourself, but you're still legally on the hook? You mentioned vicarious liability earlier.
Yes, vicarious liability. This is a legal principle where a defendant is held criminally responsible for the actus reus of a third party, even if the defendant didn't directly perform the act.
Liability by association.
Essentially, yes.
Yeah.
Historically, this was quite limited in criminal law. Even today, it's generally confined mostly to regulatory crimes, where the punishment is typically limited to fines rather than imprisonment.
Like a boss being fined if an employee breaks a regulation.
That's a common example. Think of a restaurant owner being liable for an employee selling alcohol to a minor, even if the owner wasn't present and didn't know. However, a significant development in modern statutes, which is a departure from common law, is that corporations can now be held vicariously liable,
For acts of their employees.
specifically for acts performed by high-ranking corporate agents who are seen as representing the corporate policy. This is a very important distinction when considering corporate criminal responsibility, which has become far more prevalent in modern law.
Okay, vicarious liability usually limited, but applies to corporations more now.
Right. Now, let's tie the act and the mind to the final outcome. There must be a direct link, an unbroken causal chain. This is causation.
Connecting the dots again.
Exactly. The defendant's mens rea, if required for the crime, must somehow cause or inspire the criminal act, the actus reus, and that act in turn must be both the actual cause, the but-for cause, and the proximate cause, the legal cause of the particular result that the statute makes unlawful.
Actual and proximate cause.
Yes, actual cause means but for the defendant's act, the harm wouldn't have occurred. Proximate cause means the harm was a reasonably foreseeable consequence of the act, and there were no intervening superseding causes that broke the chain of causation.
So it's not enough to just act with a guilty mind. That action must be the actual and legally recognized cause of the forbidden result.
Precisely.
No.
For example, if you shoot someone intending to kill them, mens rea plus actus reus, but they don't die from the gunshot wound and instead die days later from a completely unrelated allergic reaction to medication they received at the hospital.
Then you might have an issue with causation for the murder charge.
Exactly. Your act was the actual cause, but was the death from the allergy a foreseeable result, or was it an intervening cause that broke the chain? That becomes the crucial proximate cause question. Causation issues can get very complex.
Definitely sounds like it. Okay, so we have the act, the mind, the causation. What happens if you make a mistake? You misunderstand something crucial. Does that get you off the hook? This sounds like the mistake as a defense area.
It does. A mistake can sometimes negate the required mental state, acting as a defense. We primarily talk about mistake of fact.
Misunderstanding the facts of the situation.
Exactly. A mistake of fact occurs when a defendant has a misunderstanding about a material fact related to the crime. Now, under common law, the impact of this mistake depends heavily on the type of crime involved.
Back to specific versus general intent.
You got it. For specific intent crimes, remember FI Act, a mistake of fact is a valid defense, even if the mistake was unreasonable.
Wait, even an unreasonable mistake, why?
The logic is that even an unreasonable mistake might still prevent the formation of that very specific subjective intent the crime requires. If you genuinely, even unreasonably believe the property you took was yours, you didn't have the specific intent to steal.
Okay, so if you take a coat from a restaurant thinking it's yours, but it's like bright pink and yours is black.
An objectively unreasonable mistake, perhaps. But if you genuinely believed it was yours, that mistake, however unreasonable, negates your specific intent to permanently deprive another person of their property, which is required for larceny.
That's huge. So unreasonable mistake works for specific intent. What about other crimes?
For general intent or malice crimes, the mistake of fact is a defense only if the mistake was reasonable. If the mistake was unreasonable, it generally won't negate the required general mental state or malice. The law expects a baseline level of reasonableness for these crimes.
Reasonable mistake for general intent malice. Any mistake, reasonable or not, for specific intent. Got it. What about the MPC?
The Model Penal Code takes a slightly different, maybe more unified approach. A mistake of fact is a defense if it prevents the prosecution from establishing the required state of mind purposely, knowingly, recklessly, or negligently for a material element of the crime. So it's about whether the mistake genuinely negates the specific culpability the statute demands, whatever that level might be.
More focused on negating the MPC mental state itself.
Exactly. And crucially, remember our exception. For strict liability offenses, mistake of fact is never a defense.
Because there's no mens rea to negate in the first place.
Precisely. You did the act, liability attaches, mistake or not.
Okay, that covers mistake of fact. What about mistake of law, thinking the law was different than it is?
Generally, that's a much tougher defense to make. Under common law, a defendant's mistake of law is almost always no defense, even if the mistake was reasonable.
The old ignorance of the law is no excuse.
That principle largely applies here. However, the model penal code offers a bit more nuance, as it often does. While the defendant's simple lack of knowledge of a criminal statute is still no defense under the MPC, an honest mistake of law may be a defense if it actually negates the requisite mental state for the crime.
How would that work?
This often comes up in scenarios where a defendant relies on an official interpretation of the law, say, advice from a relevant government official, or a court ruling that turns out to be incorrect. If they honestly relied on that official statement and believed their actions were lawful, that might negate their mens rea if the crime requires knowing conduct is unlawful. But it's a very high bar and usually requires reliance on an official source.
So generally no defense, but maybe if you relied on an official statement under the MPC?
That's a good takeaway.
Okay, now imagine you aim for one target, but you hit another. You shoot at person A, miss, and hit person B. Are you off the hook for hitting B? Not necessarily right. This sounds like transferred intent.
That's exactly what it is. Transferred intent, sometimes called the unintended victim rule, is a legal construct. It basically supplies the required intent when a defendant acts with the intent to cause harm to one person or object, and that act directly results in harm to another person or object.
Like the intent transfers from A to B.
Precisely. So in your example, if you intend to shoot person A, but your bullet misses and strikes person B, the intent to kill person A transfers to person B. This allows you to be charged with a crime like the murder or battery of person B, even though you didn't specifically intend to hit them.
Which crimes does this usually apply to?
It's usually confined to specific crimes, primarily homicide, battery, and arson.
Okay. Are there limits?
Yes, a key distinction for you to remember, and it's a common exam trap.
Yeah.
This doctrine applies only to bad aim cases.
Bad aim?
Meaning, you intended to harm someone specific, A, and you ended up harming someone else, B, by mistake, because your aim was off, or the circumstances changed unexpectedly. It does not apply to mistaken identity cases.
What's the difference?
Mistaken identity is where you intend to harm the person you actually do harm, but you're just wrong about who they are. You think person B is person A and you shoot B. In that case, you have the direct intent to harm B, even if based on a mistake. So you don't need transferred intent.
Ah, okay. Bad aim, transferred intent needed. Mistaken identity, direct intent, even if mistaken.
Exactly. And another important point. Transferred intent generally won't satisfy the mens rea requirement for attempted crimes against the unintended victim. The crime must be completed for this doctrine to typically apply.
So if you shoot at A, miss, and hit B, you can be charged with the completed crime against B using transferred intent. But what about A?
You could potentially be charged with attempted murder of A, based on your original intent towards A and the substantial step you took, firing the gun. But the transferred intent doctrine itself primarily applies to the completed harm against B.
Got it. That's a subtle but important distinction.
Very. And quickly, just a note on jurisdiction. Where can a crime be prosecuted?
Right. Where does the case get heard?
A state generally has the authority to prosecute a crime if any part of that crime occurred within its boundaries. This means if the conduct started there, or the result happened there, or even a key element took place within that state's geographic limits, the state can usually assert jurisdiction.
So crimes crossing state lines can get complicated jurisdictionally.
They can, but the general rule is that if part of the crime touches the state, jurisdiction is likely proper there.
Okay. Now, crime isn't always a solo act. Often others are involved. How do we assign liability then? This takes us into the complex world of parties to a crime.
It does. Who else is held accountable? And what are the different legal roles they play? Historically, common law had very specific and somewhat rigid definitions for parties to a crime.
What were those?
Under common law, you had the principal in the first degree. This was the person whose criminal act or omission constituted the actus reus of the crime, the main actor physically or constructively present.
The doer.
Right. Then the principal in the second degree. This person aided or abetted the principal prior to or during the crime and was also physically or constructively present. Think of the lookout or the getaway driver waiting right outside.
Helping at the scene.
Yes. Then an accessory before the fact. This person also aided or abetted, providing help or encouragement before the crime, but was not present at the scene. Maybe the mastermind who planned it but stayed home.
Helping beforehand, but not there.
Exactly. And finally, an accessory after the fact. This was a person who aided or assisted a known felon in avoiding apprehension or conviction after the felony had been committed.
Helping them get away after the fact.
Right. And it's crucial to note that being an accessory after the fact is generally considered an independent, separate crime. You're not liable for the original felony itself, but for the distinct crime of obstructing justice or hindering apprehension.
So those were the common law categories. Sounds a bit complicated. How does the modern view handle it?